I want to talk to you today about how the COVID-19 pandemic is affecting trial delay in our Ontario criminal court system. What happened this summer, of course, from March right till July 6th, is that the courts were largely put on pause. There was no trials going on. Every trial was being put over. Now, by the way, on July 6th, many of our courthouses have renovated a limited number of courtrooms for trials. So, for example, let me give you two examples. In Kitchener, 2 out of many trial courtrooms, only 2 have been renovated. In Windsor, same. So on a given day in those jurisdictions, there's a whole bunch of trial courtrooms running. Now we only have 2. So what's going to happen to all these cases that were put on pause? Under our Canadian Charter of Rights and Freedoms, everyone under Section 11B has a right to be tried within a reasonable time. And the Supreme Court of Canada has put timelines on that. And in a case called Jordan, R. Regina against Jordan, those timelines are as follows. For a case in the lower court and the Ontario Court of Justice, from the date of the arrest until your trial, that has to be completed in 18 months. For a case that goes to the Superior Court of Justice, those timelines are 30 months. Now, what would happen is if those timelines are not met, it would be your right to bring an application to stay the proceedings, which is effectively a withdrawal. So if you're not the one who caused those delay, that it was due to institutional resources, actions of the Crown, etc., if those timelines aren't met, your case could easily be thrown out. Is that going to happen with all the cases that went on this summer that have been put over, all the people in custody cases put over, all the new charges? Is that going to happen? It does remain to be seen. We don't really know. There is a perception that it could. Because of that perception, the Crown attorneys are offering a lot of pretty good deals these days to hopefully remove the cascading bottleneck. But now we've got a problem. Limited number of courtrooms open. So defense counsel, if cases extend beyond the 18 months, are going to be making these arguments, or the 30 months in Superior Court of Justice. Crown attorneys are going to argue quite properly in this sense that, well, COVID during the summer, at least when it was on pause, that was an exceptional circumstance. That should not go towards the period. And I'll concede that. That should not. But now that the courts are reopening, the bottlenecks there is cascading, and defense counsel are going to argue, well, now, give me my trial date now. I'm ready to set a trial, and it's going to be very interesting, the decisions that are going to come forward, whether delay meets the Jordan guidelines or not. Again, the Crowns are going to have to argue exceptional circumstances. Defense counsel is going to have to distinguish it. But what happens when all the courts get renovated? Now we're completely in a position to argue, well, this is not exceptional circumstances right now. So it's going to be an interesting argument. I don't want to make a prediction. I do predict that there could be cases thrown out for delay. I do predict that the Crown attorney is going to keep offering deals to try and avoid that. And the problem may be removed because of that. But what's the good news for people? Well, you're going to get reasonable deals going forward. The Crown doesn't want murder cases thrown out. They don't want serious charges thrown out. On more minor charges, there may be a lot of deals offered. So the Crown's going to have to come to grips with this. They're going to have to ask themselves on every case, even a murder case or a sexual assault case, apply the proper tests. Is there a reasonable prospect of conviction? That's a very low-level test. If the answer is no, in my respectful view, and that's the proper test, the Crown should pull that charge because you don't want it affecting a legitimate charge where there is a reasonable prospect of conviction. So the message I want to deliver to you is this. For those who retained, for example, our office this summer, who wanted a trial date, they weren't able to do that, but we were able to move your file through the normal steps. We were able to meet with the Crown, get a judicial pretrial, get your case set for trial. Now we're in a position to do that. You're ahead of the game for someone who sat in their hands. If the person who sat in their hands, it's going to take them weeks to be in a position to set a trial date. They did nothing. That delay is arguably on them. For the clients who took those steps, if delay emerges, they're going to be able to take advantage of that and perhaps also get a reasonable resolution. And when I say a reasonable resolution, don't get me wrong, the Crown's not giving away the farm in this province. They're still offering reasonable deals to avoid the cascading problem of delay and to hopefully avoid getting serious criminal charges thrown out. No one wants that. As a criminal defense lawyer, I don't want that. I'm a member of the public as well. Crime should be prosecuted. But on the other hand, I have a duty to my individual client to press all issues, including if delay emerges. So that's basically what's going on in the province. We don't truly know yet how bad the backlog problem is. I can tell you this, though. We're all worried about it. As a member of the public, I am. There's a great perception that there is a backlog, and it's probably going to emerge. The only way it's not going to emerge is if the Crown could efficiently move cases through the system and we can get back to renovating all our courthouses. I don't know when all of the courtrooms are going to be renovated to make them COVID friendly. They're talking about November. Who knows? And by the way, jury trials have been suspended till September. God knows when they're coming back. I would be shocked if they resume on September 20th. I don't think they will, but that remains to be seen. So you've got people charged with very serious crimes like murder and sexual assault or rape who are languishing custody waiting for their jury trial. So there are problems going on in the courthouse right now across the province. I can tell you this, I think the Crown Attorney is effectively dealing with this, taking the proper steps to avoid the delay, and they should be commended for that. And I encourage them to continue to do so.